Everyone, welcome again to Legal Pundit. There are platforms where I am offering a free legal advice. My first advice is free of cost, and there are matters where I am, handling the cases or serving notices pro bono. And all these 14 years of my practice, uh, I have mostly handled the corporate matters and you know but when we established Legal Pandit, and now that I have experts in all fields related to taxation, matrimonial disputes, properties, criminology, civil, for that matter. So we have started taking up each and everything that's coming up our way, and I am really shocked and surprised to find out that every single day, there are forums where I am posting my legal advice, and people are connecting with me on personal window as well to seek an advice on matrimonial disputes. And there are so many divorce cases rising up, and being an advocate, it is always profitable for me to initiate a proceeding like this or take up a matter. Though I, on personal level, I always advise them, or whatever the advice I drop there, I advise them to, even if there are any matrimonial disputes, kindly try to settle them across the table. Try to enter into a divorce proceeding by mutual consent, because divorce proceeding may take up a very long time as well, and there are cases which are pending in court from 5 to 8 years easily. And during this process, the ones who are suffering are the kids. It's our kids who are suffering in silence during these matrimonial disputes or the divorce proceedings. So I thought of making a descriptive video on divorce, and in this series we will discuss how criminal charges are dealt with in the divorce proceedings, how matter when it is related to the dispute related to the joint account or the property is in question, and how the matter goes to the civil court, how a simple divorce proceeding can be settled across the table by initiating a divorce by mutual consent, which goes into the family court. So we will try to understand the three family court matters, the civil and the criminal. When it goes to the criminal court, what are the charges and what are the conditions. And to start with, today we will discuss about the divorce by mutual consent. There are three ways. First, by mutual consent. Second is when it goes in the family court and the disputes are related to maintenance, alimony, custody of children, disputes related to distribution of property, the joint accounts, or Stridhan is in question, and they are not both the parties are not coming up on a common ground, and the court, the matter goes into the takes the shape of a civil suit. If there has been a cruelty, harassment, abuse, physical, mental, sexual, marital rape is there, abetment for suicide, attempt to murder, then definitely there is an FIR, and the case goes into the criminal court. Now, for a divorce under Section 13 of Hindu Marriage Act 1955, it is very important, first of all, that the parties must have been married according to the Hindu rituals. It could be a registered or a non-registered marriage. Now, if there is no FIR involved, if there are no big disputes of property where the parties are, divorce by mutual consent can only be obtained when both the parties, husband and wife, they agree and they're willing to get separated. They agree on the common terms and conditions. Both of them can have or appoint their lawyers who can sit across the table. They can present their drafts. They have to agree on the common points, and at the end an MOU is signed, and then finally the divorce petition is filed in the court. आप किसी मैटर पे अग्री ही नहीं कर रहे हो, या एक अनड्यू इन्फ्लुएंस किसी के ऊपर आता है, कोई थ्रेट है, और कोई टर्म्स एंड कंडीशंस हैं जहाँ एमओयू पे आप एक म्यूचुअल अग्रीमेंट पे नहीं रीच कर रहे हो, देन इट इज इम्पॉसिबल टू गेट दिस रिजॉल्व in this manner. Then you have to move to the court, and then the court will decide accordingly. Now कहाँ आप फाइल कर सकते हो डिवोर्स म्यूचुअल कंसेंट के लिए? फर्स्ट ऑफ ऑल द प्लेस वेयर यू वर मैरिड, जहाँ आपकी शादी हुई थी उस जगह से आप फाइल कर सकते हैं, वहाँ की कोर्ट से। जहाँ आप करंटली रिसाइड कर रहे हो, दोनों हस्बैंड एंड वाइफ जहाँ रिसाइड कर रहे थे उस सिटी में, वहां से आप फाइल कर सकते हो। लेट्स से इफ अ वाइफ इज लिविंग सेपरेटली and if she is residing with her parents or residing in any other city for her work, or she's separated and she's living in some other city, she can file for the divorce from that city or town as well. Are the terms and conditions upon which both the parties have to agree, and then only an MOU is signed. MOU is Memorandum of Understanding. When both the parties reach to a common understanding, somebody has proposed something and the other party does not have an objection to it, and they agree to it, whether it is co-parenting related to your kids, whether it's related to the expenses of education of children, the health expenses of children, the expenses related to the higher education of children, related to any decisions which should be in during mutual consent divorce of by mutual consent. It should be any decision related to the marriage of children or higher education for that matter, sending them to a hostel. These have to be agreed upon by both the parties, and generally they if one party who has the custody of children, they should always be informing the spouse or the other party about the major or the life-changing decisions or any kind of health decisions related to the kids. If they have a custody, they have to inform the other party. So all these terms and clauses are laid down in an MOU, apart from distribution of joint property, any joint lockers that you have, house or residence where the other person or kids are going to reside. The settlement is very important and it is necessary. The clauses related to the stridhan, joint investments, any kind of expenses which were incurred during the marriage proceedings, and if a wife claims them back, then she has a right to do so, and if it is mutually agreed. The expenses or any kind of maintenance if she is claiming, or if there is any sum involved for the fund, time, full and final settlement in the name of alimony, and it has been agreed by the other partner, then that is again to be laid down and clearly mentioned in the MOU, which is to be signed by both the parties, and the witnesses and the lawyers of parties should be present, so that once this process is completed, the second step is then after you have appointed a mediator or arbitrator, second step is after filing the MOU, the petition is filed in the court for the proceeding of divorce. Husband and wife are already living separated, and there are a lot of disputes related to expenses or any other issues for that matter. It is important to appoint a mediator or an arbitrator. If you go to a court and file a suit against each other where there is no party has previously initiated for the proceedings by mutual consent, then also a court will appoint a counselor, a mediator for both the parties, so that they can agree upon the mutual terms, and they grant a cooling off period of 6 months to the party. And this is done only when there is a condition that the husband and wife are living separated for the last 1 year already. Then also there are mediators which are appointed by the court from the list of mediators who have previously handled such cases. Otherwise, when you have not yet filed for the divorce petition and you want to settle terms on your own, and you can appoint from the other online agencies as well, a counselor, a mediator or an arbitrator, you can say, who can make both the parties come and settle on the common ground so that an MOU can be signed and further proceedings related to the divorce petition can be moved to the court. Now recently this cooling off period, which is a period of 6 months, this is also waived off by the court. So there was a compulsory period of cooling off after the first motion. See, when a divorce petition is filed in court, then on first motion divorce petition is filed, there are ways of mediation, counseling, and if they do not agree and they still adamant to get divorced, then there is a cooling off period which was granted by the court, and after that cooling off period the second motion was moved, and then finally a divorce decree was granted. Now this there are conditions where this cooling off period is waived off by the court as well. Apart from the custody of children, there are some important points which are to be mentioned in the MOU regarding the visitation rights, the co-parenting rights, the education expenses, any important decision, life-changing decision related to the child that should be informed to the other spouse, as I mentioned, and visitation rights, terms of co-parenting, and if joint custody, then how the shared parenting is going to take place. I mean, for how much duration a child will stay with the mother, or how much duration the child is going to stay with the father, and expenses related to obviously their health and education, they need to be clearly mentioned in an MOU, which is a very important thing apart from the maintenance amount and the alimony which is claimed. So these are the very two important aspects which should be very clear in the MOU to avoid any kind of indisposition in future. Alimony is one time full and final settlement, जो एक अमाउंट वाइफ क्लेम करती है अपने हस्बैंड से, या आजकल अगर हस्बैंड अर्निंग नहीं है, वाइफ अर्निंग है, there is a huge difference in their salaries, even if a wife is earning, then also she can claim for maintenance or an alimony amount. So this is the amount which is a full and final settlement. And why do lawyers encourage for an alimony amount? Because this is one time full and final settlement. It is calculated upon the average monthly income of a person. It is expected that if he continues to work for another 10 or 20 years, what his salary is going to be in another 10 or 20 years. And according to the inflation rate and her, let's say it is considered that her lifespan, if it is going to be 20 years from now, so that money should be sufficient enough for her survival. Now, what is the advantage of claiming that one time full and final settlement amount in the name of alimony? If a girl is young, let's say, and they are going under the divorce proceedings and she wishes to remarry again, then it is always advised to claim for a one-time alimony, because maintenance amount is paid monthly to the wife, separated wife, and children. It is a monthly amount which is fixed by the court. Now, if a girl remarries, then this maintenance amount is no more paid by the husband. But when the monthly maintenance is taken into consideration and is calculated on the basis and a big lump sum amount for one-time settlement, for full and final settlement, then this alimony amounts come into the question, which is always suggested that girls should demand for an alimony rather than maintenance amount. If there is any settlement of property, joint assets, joint accounts are there, lockers are there, or the property where joint investment has been made, then this is again to be very clearly mentioned in the MOU and settled. Either the party, if there is a joint property और दोनों ने पैसा दिया हुआ है, तो एक पार्टी जितना इन्वेस्टमेंट अमाउंट है या कैलकुलेट करके the current rate of the property in today's date, they can pay the 50% or whatever the percentage of investment was there from the other party. They can pay that amount to the other party, and then they can have a complete ownership of the said property. This is another good way of settling dispute. Or they can dispose of the property and whatever comes in their hand according to the ratio of investment done, they can appropriate the amount which is received after disposing of the property. Very important, if there is any pending litigation which is going on amongst both the parties, it is already pending in the court, then first of all that litigation should either be withdrawn or settled before entering into a divorce by mutual consent. This is the condition of signing an MOU or entering into a terms by mutual consent, that you should first of all settle any kind of, if there is a police complaint, if there is an FIR, if there is a criminal complaint lodged, if there is already a litigation related to property dispute or criminal proceedings are going against the husband after a wife has complained and now they want to mutually settle all this. So she has to either withdraw the allegations or they have to settle all these pending litigations first of all and then go for the divorce by mutual consent. Another important condition is that parties have to prove that they were living separated for the period of 1 year before filing for this petition. Now, 1 year living separated either in different houses or under the same roof. Now, when they show that they are living separated, they were not living as husband and wife, but they are living under the same roof, then it gets sometimes little tricky and difficult to prove or come to a settlement in that term. If they are already living separated from since last 1 year, divorce petition is moved in the court after settling of all the terms and conditions and signing of MOU. Then the first motion is passed. After this first motion is passed and there is no reconciliation, counseling and all is not working, and both the parties are adamant that they want to go ahead with the divorce proceeding, then the court will give a 6 months of cooling period, which is now being waived off depending upon the terms and depending on the conditions. In not in all conditions they are waived off, but in some conditions they are waived off also now. So the 6 months of cooling period is required to file and go ahead for the second motion in the divorce proceedings. Now, filing of petition in the family court. So we are moving to the court for divorce by mutual consent, and there is a joint petition which is to be signed by both the parties. They have to jointly move a petition in the court that all the methods, measures and efforts of reconciliation has failed. They are not able to live together under one roof. Since last 1 year or more, they are living separated. They do not have any kind of relation as of husband and wife, and in future again it is impossible for them to live together or continue with this marriage. So this is a joint petition signed and agreed by both the parties. It is moved to the court, and then this is known as the joint petition filing in the family court by both the parties, where they have agreed to dissolve their marriage by mutual consent. Documents required, you need to give your address proof, you need to have a passport size photographs, 2 passport size photograph of each spouse, that is required. Your identity proof is required, your shadi ka card is required. If your shadi was registered, then a registration certificate is required, and 4 photographs of your marriage proof. They are required to be attached, and marriage card, as I mentioned, and memorandum of understanding, which we've been discussing so far, the MOU, which is being signed by and agreed upon by both the parties by free will and free consent, that is to be attached. And you have to provide an evidence that they are living separated since last 1 year. And as I mentioned, that if you are already living in different cities, or the wife has moved out of the house, if the husband has moved out of the house, or you're living in the same city but under different roofs, then you have to provide an evidence. You can show your rental agreement, or you can show that you were living at your parents' house or so on. But now when husband and wife are living separated, but they are living separated under the same roof, then it gets very difficult to prove it. And in those circumstances, the cooling off period, as I said, it can be waived off also. Then it gets difficult for this cooling off period also to get waived off, because court then grants them time that when you're living under the same roof, then they should be given some cooling off period so that they can rethink about the decision they are going to make. conditions are satisfied, your petition is filed, then there is an appearance before the judge of family court, and this is the first motion, as we say. And the court may go through the petition. They may try for reconciliation. If the reconciliation is not possible and it is not reached, then the matter proceeds further. Then comes the joint statement of oath. Both the husband and wife, the court orders the parties to the joint statement to be recorded on oath, which is to be signed by both the parties, and thereafter then the first motion is passed. After the first motion is passed, the court may give a cooling off period of 6 months, which can be waived off also in certain conditions, which can even extend up to 18 months. And then after the first motion, 6-month time period has, let's say minimum 6 months time period of this cooling off period, what we say, has passed, then the court grant for the second motion. And maximum period for filing the second motion is 18 months, as I said. And when the second motion is heard, the final hearing is done, and at the end eventually the divorce is granted. So this is all the process of getting divorced by mutual consent, which is, I think, is the most sophisticated and time saving, because whenever there is a divorce proceeding going on, people believe more on taking revenges or teaching each other a lesson and fighting cases for years without thinking about the future of their kids. And it gets very important to encourage more and more divorce proceedings by mutual consent. If you are demanding an alimony, if you cannot maintain yourself, you have given up your career, you have spent a lot of time raising your kids, you have a problem finding job, or all these conditions are there, then it's fair enough that a woman should get maintenance or one-time alimony to maintain herself, so that she can arrange for a shelter for herself. When you are not sure of conditions these days, how much time will it take for her to find a job or be independent for that matter, and there are a lot of expenses related to education and health involved of kids. So considering all these things, an alimony or a maintenance amount is fixed for the women. If you agree upon those terms and conditions mutually, it is well and good. Otherwise, there are litigations which cost you so much time, energy, money. And I would repeat, it's our kids who are suffering in silence during these proceedings. Coming months, we are going for a lot of arbitration proceedings. 2-3 matters are on floor. 2 matters of divorce cases are already on floor, unfortunately, of my known people. And now I am encouraging people on all the social media platforms to go for reconciliation proceedings. Legal Pandit is offering mediation and arbitration services. Those who want to come, settle down their disputes, get their MOU prepared and get it signed amicably, they can contact Legal Pandit, and which is the best way, I feel. Otherwise, a lot of people encourage and provoke कि हम तो तुम्हारा केस में मजा चखा देंगे, माफी मंगवा देंगे, इतना क्लेम दिलवा देंगे, इतना कुछ होगा. होती है. When there are genuine cases, there have been harassment is there, physical abuse, attempt to murder. बहुत genuine cases में यहाँ जो होता है, wherein it is important to go for a criminal proceedings and get the FIR filed immediately. But if it is not so, and if there are any disputes जो civil court में जाने वाले हैं और बहुत time लगने वाला है, related to, as I mentioned, custody of children, property distribution, maintenance and alimony amount, if that can be solved amicably, sitting across the table and agreeing to some common terms and conditions by signing an MOU, then every party must consider moving ahead for the divorce proceedings by mutual consent. Keep following Legal Pandit. Thank you.